Hi, thank you for joining us today at the talk about rentals in Israel. A little about myself. My name is Yair Givati. I work for Yair Givati and Co., the firm that was established by my father in 1969. We predominantly do real estate. When I joined the firm about 15 years ago, we started working more with the Anglo crowd, helping navigate the system, the differences between Israel and the US, in managing the expectations of people, and that became our bread and butter. The majority of our clientele are people who are looking to move to Israel or buying and renting from abroad. The idea is to try and hold and guide them by the hand through the process they are facing in Israel. What are we going to cover today? Today we're going to speak about rentals in Israel. More specific, we'll be dealing with the lease terms, maintenance of the property, other costs involved with renting in Israel, and a new and updated law, which is already a few years old, the changes that have happened in the rental law in 2017, which came to help the renters of the apartment protect their rights more than it has been till then. I would like to preface and say, that there's a lot of information out there you can find on Google, on groups and forums, on Facebook, rumors that people have heard, friends that told the people some information. It's very good to try and educate yourself and find all the information, but a lot of the information out there is not necessarily current, up to date, or even some things that were wrong. The internet takes everything and you don't necessarily know what's wrong and what's right. When it comes to rental, most of the issues that we're facing with clients who come to us, the trouble that they had with the apartment or with the landlord, comes from not having a lawyer review your contract prior to signing it. And the trouble is that people, in hindsight, it could be hard to correct it. So we highly recommend taking a lawyer to review your rental contract. Yes, does involve cost, but it's worth it in order to protect your rights in the long run. We're very happy you guys decided to move to Israel and rent a place for you to start your journey here in Israel. It's very important to know that when it comes to renting in Israel, it's very unlike what you know and have in the US. The law in Israel is not as protective of the tenants, and it's something that you need to know ahead of time because it's very, very different to how things are in the US, where the tenants are very much protected. Until 2017, the law had very little protection to the tenant, and in 2017 they made a big change. It is so far from protecting the tenants enough, but it's definitely a step in the right direction, and you have what to lean on, and you are protected much more than you have been in the past. Let's start from the basics. A written contract. One of the changes in the law in 2017 was requirement to have a written contract. Meaning trying to make sure that everything is done in writing to protect. So there's not going to be based on memory of what the landlord said, what the tenant said. The law tried to make sure that it's done in writing to prevent any disagreements in the end. But the law also does state that the fact that it's not a written contract doesn't invalidate the contract. So a handshake, a WhatsApp message, an email does and could count as a valid and full-fledged contract, despite not being in writing. But the recommendation of all the requirements of the law is to be doing it in writing. And of course, this is also our recommendation to make sure there's no misunderstanding or disagreements at the end of the lease. The language, many times we get the questions, can the contract be in English? So yes, definitely. And we many times do that, especially when both parties are Anglos. It's easier for them to have an English written contract. I would definitely go ahead with it. There is no issues with it. And if you want, you can definitely ask for it. If the landlord is Israeli and does not speak English, not necessarily he would agree to it. But we see more and more now that we are able to sign rental contracts in English. It is very important to include in the contract the property description and proof of ownership. We many times see that someone is managing the apartment on behalf of someone, and then they sign the contract or they even put their names in it. This is of course not valid. You want to sign the contract with the landlord itself, and if somebody is signing on behalf of the contract, you want to make sure that they have a power of attorney to actually represent and sign on behalf of the owner. Rent and payment terms, of course, this is one of the basics. You want to make sure that it's written in there how much you pay every month, and how often, when do you pay it, what's included in the payments, and how are you going to make the payments every month. Of course, the lease period and options to extend or end early. All this, especially to prevent issues in the future about continuing rent or not, you have to make sure that it's part of the rental contract. Keep in mind that in Israel, if you get a 2-year contract, that's probably a long-term lease. In Israel, most of the landlords want to rent it out for 1 year, maybe 1 year with an option to extend for another year, but you definitely do not have 5 to 10 years rental contracts. Those are very, very rare. And so keep in mind when you do it, when you move to Israel, that this is not something that you will find. If you do, you could be lucky in a way, but it's not the common of what you'll have when you rent a property in Israel. In Israel, most of the time, apartments, when you rent them, are empty. And when I'm saying empty, I'm talking about total empty, not including any furnishing and not including any appliances, not even a stovetop, an oven. These are things that tenants usually come and bring with them and take it out with them when they leave the apartment. If you happen to stumble about an apartment that is furnished, make sure that you take a record at the beginning, what's included, what is the owners, how you have to leave it, who's going to maintain everything. These are very important points to make sure that are included in the contract, so there's not going to be any disagreement at the end of the lease. And of course, what's very important here in Israel are the securities. The securities in Israel are very, very different to what you're used to in the US. The biggest question we always get, which is part of any rental contract, are open checks. Now, open checks, they're not completely open. They're usually made out to the utility companies like the water company, the electric company, the gas company, the maintenance company, but they're not dated and there's no sum. You give it to the landlord as a security that if you have any debt, the owner, the landlord, would be able to fill them out and then cash them. This is not really negotiable. In Israel, all rental contracts have it. And I know that for you, it's very, very strange to give such checks, but this is one of the basics you have to be aware of and expect it when you're signing a rental agreement. The next topic that I want to touch when it comes to rentals is the maintenance of the apartment. In the past, the landlord used to throw all the cost of maintaining the apartment on the tenant. This has changed in the recent law and limits what is the responsibility of the tenant and states what are the responsibilities of the landlord. We'll touch about it a bit later on when I'm talking about the changes that happened to the law in 2017. The repairs to content or appliances, it's something, again, you want to make sure that it's part of the contract to state clearly who's responsible for what. And then, vacating the property at the end of the lease, it's very important to know what state you have to bring back the apartment to the landlord. It is very common, and unlike in the US, that the tenant would have to actually paint the apartment at the end of the lease. And many leases nowadays even state what paint you have to use, what color, etc. This is the extra expense you have to keep in your mind when you leave the apartment. There's something you have to do prior to vacating. So if you know that your lease ends on March 1st, it doesn't mean that you just leave the apartment on March 1st, but on March 1st you have to return the apartment in a good and clean condition and paint it. It's not that once you leave the apartment, then you have time to take care of cleaning or maintaining the apartment. It's something you do prior to handing the apartment back to the landlord. There are two main types of insurances. The first one is structural insurance, and the second one is content and third-party liabilities. In the past, landlords asked the tenant to pay for all these insurances. The new law, as we'll touch soon, limited it to what the tenant is responsible for and what the landlord is responsible for. What other costs are involved with renting in Israel? Unlike in the US, when you rent, and usually the rent includes everything, including all the maintenance, the fees, the taxes, the cost of running the apartment, in Israel, it's just separate. With the rental that you're paying to the landlord is in a way net, and all other expenses are to be paid by the tenant. All the utility bills, such as water, electricity, gas, phone line, internet, maintenance, there are no now, which we'll touch in a second, all have to be paid by the tenant, and the landlord is not responsible for them. The VAT, the maintenance fee, it's split. Anything to do with the ongoing running of the apartment is to be paid by the tenant, But if there are any structural upgrades to the building, changes they're making to the building, these are payments that have to be paid by the landlord and not by the tenant. And please be aware of it, because sometimes the landlord will tell you, okay, you have to pay for it. Arnona. Arnona is a municipal tax. It's a tax that's paid by the tenant. It's to cover all costs of the municipality, such as cleaning, garbage collection, schooling, etc. It's something that it's the responsibility of the tenant to pay. The renter insurance, as we said before, and we'll touch again a bit later when we're talking about the updates to the law, it's something that has to be paid by the renter. And other maintenance, the landlord, according to the new law, if there are small fees involved with fixing small things, is something that the landlord can demand that the renter would pay for. Now, what did we have in the new and updated law that made difference to protect the tenants more? First of all, and you'll laugh at it, it's livable conditions. You know, there's a famous picture here in Israel of an apartment in Tel Aviv, which was a little hole in the wall. And the bathroom, shower, and kitchen were all in one tiny room. And the law came to change it to make sure the landlord don't try to rent any small space they have, but it has to be a livable condition, a normal apartment. They're not allowed to rent something that should not be livable. Repairs, the misuse and normal use of the apartment. In the new law, the legislator separated between what's normal use of the apartment and not. So if you come with a 5 kilo sledgehammer and break something, that's definitely a misuse of the apartment and you'll have to pay for it. But anything that you use normally and out of normal wear and tear of the apartment, that's something that the landlord has to cover. That being said, the law does give the landlord an option that to require the tenant to pay minor fees for fixing small things in the apartment. But again, it has to be very, very minor, and it's not something that he can say you have to fix everything. These are small repairs from normal use of the apartment. Mutual cancellation rights. So in the past, what the landlords used to always like to do and add in the contract is that they can cancel the agreement at any given time, which is good for them, but the tenant could not break the lease and leave. Well, the new updates to the law came and did, it says that you don't have to have a break clause in the contract, but if there is a break clause in the contract, then it has to be mutual, meaning the landlord can't keep it just for himself. If he has an option out, so does the tenant. And then this is what we're talking in the next point, basically the option exercising in the cancellation right. If there is a clause to cancel the agreement, then the landlord has to give the tenant no less than 90 days notice that he wants the tenant to vacate the apartment and cancel the agreement. But if it has to have also a clause in favor of the tenant, that if the tenant wants to leave, he can give the landlord 60 days notice and leave the apartment. I would just want to emphasize again, you don't have to have such a clause in the contract, but if you do have, these are the minimum times that the landlord and the tenant have to give notice to each other in order to step away and move out of the apartment and cancel the agreement. When it comes to option exercising, as we said before at the beginning, you don't always have an option. Many of the times the landlord would do it year by year, but sometimes they would give you a certain option period to exercise and stay for longer in the apartment. The first thing I would like to say about it, that sometimes you have to notice, is it really an option? Many times what the landlords do is put a clause that you have an option, but the option is subject to both parties, let's say, agreeing to a new rental amount. So if the landlord is that wants to kick you out, he can then double and triple the rent, and you of course will not exercise it, and then it's not really an option. So if you do negotiate an option period, you have to make sure that it's a real option for you to extend it. You have to make sure there's no ambiguity when it comes to what are the conditions to extend or have an option period. And usually when it comes to it is also the landlord wants to know whether you continue or not. So you have to give a minimum of 90 days notice period that you want to extend it. If you pass the 90 days before the end of the lease, the landlord can tell you, okay, I chose not to let you exercise it. You have to make sure you notice the time that when you have to give the notice by, so you will be able to exercise the option period. When it comes to purchases or upgrades to the apartment systems, So as we said before, if major system breaks in the apartment and it's not due to any misuse of the property or the system, then it's the landlord's responsibility to fix it. There are usually, when it comes to appliances, that the landlord have the right to say, okay, if they break down, throw them out, and it's not including the rental, and you'll have to buy one for yourself. If you do, of course, it's your property, and once you leave the apartment, you take it with you. If you want to buy and add certain things to the apartment, first of all, it's most commonly would have stayed in the contract that you had to get the landlord's permission. If it's something like a cupboard that you can take apart when you leave, then you don't have to ask for permission. You can just take it when you leave. But if it's something that is connected to the wall, you have to get the landlord's permission to do so. And at the end of the lease, the landlord can tell you either leave it behind, or you can take it out, and then you have to fix anything that broke down, or anything the wall that it was connected to, before you hand over the keys back to the landlord. Content and third-party insurance. As we said before, the insurance is one of the major changes that happened in the change in 2017. Until that point, the landlords usually ask the tenant to pay for all kinds of insurances, including the building insurance, the structural insurance, the content and third-party liability. The change in the law said that the landlord cannot require the tenant to pay for the building or structure insurance. This is something that he would have to pay for by himself, but he can require for the tenant to get the content and third-party liability. I know it's strange because most people do like to get insurance, but this is something that the law permits the landlord to require for you to pay for as part of the rental agreement. We usually ask the landlord to make sure there's also building insurance, a structural insurance, that if something happens and breaks any of your content, that he will be liable and cover it. But the law does not state that the landlord has to give it. And sometimes they decide to do it, sometimes they don't decide to do it. We of course try to recommend adding it to the agreement, but it's not something that's required by law. The third-party payments. There will always be some agents and lawyers that are involved with the rental process. The lawyer, the landlord would usually have a lawyer to review and prepare the contract. And as we said at the beginning, many times tenants do not take a lawyer. They want to save the costs involved with it. In the past, the landlords used to say, okay, you also have to pay for my lawyer's fees, my legal fees, for preparing and signing the agreement. In the new change to the law, it clearly states that the landlord is not allowed to throw his costs for legal fees on the tenant, and it's something that if it does, it's illegal and you can ask them to remove it. When it comes to agents, it's more complicated. The change to the law did try and change it so the landlord will not throw the cost of an agent to find a tenant on the tenant. And it does state that the landlord has to pay for his agent. But in Israel, there are no limitation on an agent basically taking for both sides. Then what usually happens is that the agent will sign you on a contract with him that you'll pay his commission upon signing of the rental agreement. This is something that the law tried to change, but it didn't work so well. Well, the intent of the legislator was that the landlord would only pay for the agent, but because it wasn't clearly defined, as I said, that the agent does not have to show you the apartment without you signing the contract. So essentially, you will end up paying an agent, even if he's representing both the landlord and yourself. The next change, which was made in the law in 2017, and is actually a very good change to protect the tenants, is with regards to the guarantees that the tenant has to provide the landlord. Until 2017, this was very much an open-ended subject. The landlord could decide which type of guarantee, how much is going to charge, and there were literally no limitation. The change that they made limits the guarantees, which cost the tenant money, to up to 3 months of the rental amount. If we look at the market right now, if 1 month guarantee is usually low, 3 months is high, and the average and what most commonly used is 2 months rent as a guarantee. Now there are 3 types of guarantees which actually cost the tenant money. These are cash deposits, which the landlord can ask for, it can bank guarantee or a bank check. These are guarantees which cost you money to issue or to pass over, and that's why they are limited. There are other types of guarantees, such as an IOU or a guarantor, which then they're not limited because they don't cost you money. It's a piece of paper that you sign in a way that you owe the landlord in case of breach of the agreement or if there's any item that were broken in the apartment. But they are not limited because it doesn't cost you money. The other three are the limited ones, and they cannot be more than 3 months rent. It's very important when it comes to the realization of guarantee that you include in the contract when does the landlord have to give it back to you. Now, sometimes people don't notice, but in the rental agreement, the landlord put it as open-ended when he wants, in a way, or when he's assured that the apartment is in good condition, all bills have been paid, that's when he'll return it. Keep in mind that when it comes to bills, for example, water bill, gas bill, water bill, electricity bill, sometimes they're issued bi-monthly. And this is why we usually say that the landlord has to pay within 60 days of you vacating the apartment to make sure that you paid all the bills and the apartment is in good condition. It's very important to have it in there because, like I said before, landlords sometimes take their time with giving it back, and you want to make sure that you get it upon return of the keys. We usually like to add a clause in the agreement itself that if you give proof that you have paid all the maintenance fee, that he would have to give it right there and then. It's a very important point to make sure it's in your contract to make sure you don't drag or keep a relationship with the landlord long after you left the apartment. The last thing I'll talk about guarantee is that before the landlord realizes any of the guarantees you're given, he has to give you a notice, give you time to fix anything that you see, anything that he sees that was not done correctly, whether it's the maintenance of the apartment or the payment of the bills. But keep in mind that if you don't do it, the landlord has the right to exercise any of the guarantees that he has. And if he does exercise any of the guarantees, let's say a cash deposit you gave him and he used some of the money, then you'll have to replenish it. If you do not replenish it, then it's a cause it could be material breach of the agreement that he can ask you to leave the apartment and cancel the agreement based on. There are 4 tips to success that I would give you now to make sure that the move is done smoothly and without any issues or problems arising. First of all, lose your expectations. Don't compare. As you know, we said a few times along this talk, the system here works differently than how it is in the US. So don't bring what you know and how it is in the US to the way it's in Israel, because it just works very, very differently. And it's very important to take the professional to guide you and help you to understand the differences and how to navigate them. And understand the process and the paperwork. How does it evolve? Like we said before, do you have to sign a written agreement or not? These are things that you need to understand the process, how it works, and that will prevent any issues arising in the future because of the expectations, as we said before. Know the resources are available. Who are there to help you? Where can you find the right information, such as Nefesh B'Nefesh talks, such as this? The information that is on websites that are up to date. It's very important to educate yourself, but make sure you educate yourself with the right information. And then the most important is basically build yourself a team. Make sure you have the right people to lean on. People that recommend it for you, people that know the process, people that are professionals in their subject. I'm here for any questions that you might have. It's been a pleasure to give this talk, and I'm available for any questions, whether now, in my email, or my phone number below.